On the supplemental, People versus Devin Martinez, 23-626 FH, 23-635 FH.
Oh. Travel last for the people.
Hi, Ms. Martinez.
Hi there.
Okay, so we are here today for pretrial. And bond violation hearing.
That's correct, Your Honor.
City.
I'm going to ask to adjourn the pretrial and address the issue of bond.
Okay, go ahead.
So, Your Honor, I did have an opportunity to meet with Ms. Martinez yesterday at the jail. There are a number of things that she's very concerned about. First of all, when she was arrested on this warrant, she indicated to me that her car and the vehicle belonging to her and her boyfriend was impounded. All of their worldly possessions are in that car. That is their source of internet. Without that, both she and her boyfriend are in serious jeopardy. So she is very, very anxious to secure her release so that she can work towards recovering that vehicle and their possessions. Additionally, her grandmother had her gallbladder taken out very recently, and Ms. Martinez has been informed that her family needs her home to help provide care for her grandmother. Finally, on September 18th, she indicated that she called the public defender's office. She was asking for the Zoom information. She indicated she was told that there was no Zoom information because it was an in-person hearing, so she was not able to appear. She does accept her responsibility for missing court on that date, but she did at least call our office and make an attempt to appear by Zoom. She was arrested on the warrant because she had left her, gone to a friend's house very early in the morning to ask for a ride to come and turn herself in. But because it was so early, she was just waiting on the porch because she knows her friend wakes up around 7 and will come out to have a cigarette. Someone saw her sitting on the porch. They called for a wellness check. The police appeared. She was arrested and the car was impounded. She indicated to me she's seeing a new therapist through CMH she's been referred to. She's also had contact with an outreach worker. She has support in the area. She's not a flight risk. She's trying to get back to work. She was working as a personal assistant at a chauffeur company called Azo Party. So she did have employment. She'll be residing in Ypsilanti. She's provided me with the contact information that she has. So I would ask the court to consider releasing her on her personal recognizance so that she can work on the things that she needs to work on because they are very urgent.
As well as rent, if I may just add, I'm sorry.
As well as her rent, Your Honor.
Mr. Prosecutor.
Yeah, I'm seeing multiple failures to appear throughout the history of these cases. I just want to point that out for the court. I think some level of assurances that she appears is necessary. So I'd leave it to the court.
You have a resident she can be to.
She's provided an address, Your Honor. So,
Yes.
Your Honor, may counsel approach?
Yeah. Ms. Martinez, come back.
Yeah.
How much time do you want?
Judge, I'm going to need 2 to 3 weeks. I anticipate a social work referral. I need to confer with our juvenile attorneys to get some background information, as well as to talk to Mr. Chavalowski about how to proceed. And then I'm going to need some meetings with Ms. Martinez.
Ms. Martinez, I'm going to schedule your pretrial for November 6th at 1:30 p.m. You're going to stay remanded. You have too many failures to appear.
No,
Last
Your Honor.
time
Your Honor.
No, last time that you were in front of me, I'm like, I talked to you about coming in and you're like, yeah, no problem. And it was really dismissive about it. And then you didn't. and
It
then you
was-
didn't show up at all. And
It certainly
I'm
wasn't.
not
how-
confident that you're gonna come back. You have a multitude between this court and district court of failures to appear. You don't come when you're ordered to come, so why would I think this would change now?
Your Honor, because there
So
are a number
on
of.
11/6 of 2023 at 1:30 PM, you'll be back for your court date. Thank you.
Really, there's nothing I can say.
Mr. Overwater, your client.
Ms. Martinez, I don't recommend you saying anything else. I don't think it's going to change the court's mind. The court's made its ruling. I will come see you. I'll have a social worker come see you. We'll work on getting you out, but you're not going to help yourself if you say anything else.
Seriously, there's nothing I can say on account of I have a job to get back to. I have bills to pay. I also have a car to unimpound, and there's nobody else who can do it except for me. And
Ms. Martinez, you would have had that opportunity had you had just come to court.
Yes, Your Honor, I
At
understand.
any of the number of times, the handful, the dozens of times that you were supposed to come and you didn't come before. And if it
Yes.
had just been one failure to appear, I would not have thought it was much to worry about.
It
But
was-
there's more than one. You're done. We're done today. Thank you.
Okay. thank
Number
you.
29, People versus Scott Matthews, 23-574.
We are on the record in the matter of the state of Michigan versus Kevin Smith, 231353. An appearance for the people, please.
Good morning, Your Honor. Omar Shahja on behalf of the people, 386-332.
Thank you.
Good morning again, Your Honor. Edward Taylor, P. 7166, appearing on behalf of Mr. Smith.
Thank you. And Mr. Smith, can you please state your name for the record?
Kevin Francis Smith.
All right, thank you, and good morning. And
Good morning, Your
today
Honor.
today is the date scheduled for a review. And the court had rescinded the order of criminal responsibility on November 9th. However, I don't believe that the Center for Forensic Psychiatry received that time in time prior to them sending us their communication, which indicated based upon Mr. Smith's determination of incompetency that they could not perform, they were not able to comply with the order to evaluate for criminal responsibility. And counsel, did you each receive a copy of the report from the Center for Forensic Psychiatry?
I did.
Yes, Judge, the people have received that report, Judge, and we do stipulate to the findings of the Forensic Center.
Okay, so this indicates that Mr. Smith has been opined incompetent to stand trial, likely to attain competence if provided with a course of treatment within the time limit established pursuant to statute.
Were you talking to me, Your Honor?
No, I'm just making a record right now, sir. And the court will note that both counsel have stipulated to the report, and the court is going to state for the record, based upon the stipulation of the report and the contents of the report, that Mr. Smith is deemed incompetent to stand trial.
Your Honor, my biggest thing is, I know you're
Excuse me, sir.
pushing towards
Sir,
the
sir,
medication,
please,
but the kid.
please do not interrupt me right now. Mr. Smith, right now I'm making a record. You cannot interrupt me right now, okay, please?
Okay.
That there's substantial probability that Mr. Smith could be expected to regain competency within the time period provided by statute if he's provided a structured inpatient hospital setting with provisions for appropriate therapeutic intervention, including compliance with medication management.
Excuse me?
The court is going to order that Mr. Smith receive treatment within the structured inpatient hospital setting and is to receive appropriate therapeutic intervention, as well as medication management. And so,
That's no
council,
good, Your Honor. The medication, I don't need the medication.
okay. And so, the court, we cannot continue at this point with this case.
Understood, yeah.
And we will set this for a review to make sure that Mr. Smith has received a bed and treatment so that he can hopefully get on his path to competency, and if not, have another pass. Anything else for the people?
Nothing for people, Judge. Thank you.
Anything else for the defense?
No, Your Honor.
All right, so counsel, there is an order regarding competency that I'll need you to prepare and submit. It's a scale form. So if you can submit that within the next couple of days, that way we can.
What did you need me to do, Your Honor?
The order regarding competency?
Okay.
Yes. And then if you'd like, if I would like for you, counsel, to include the specific language regarding the structured inpatient hospital setting. So the last portion of that paragraph, please.
Very well.
And then we'll set this for a review. Let's do February 29th. If the court order bonding conditions are continued. Anything else? Okay, Mr. Smith, I hope that you're going to receive the treatment that you need, sir.
And what treatment would that be?
Your mental health treatment, sir.
Oh, there's nothing wrong with my mental health.
Okay. All right. Have a good day. Thank you.
Thanks, Your Honor.
State of Michigan versus Eric Martin, case number 23-00425.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Eric Martin.
Mr. Martin, please unmute. State your name for the record.
Can you hear me?
Yes, sir. Please turn on your screen also.
What's going on? Hold on, I'm trying to do that here. I'm not seeing it. Okay, there we go.
There you go, sir.
This is Eric, capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N, living man, hereby threatened arrest, and appearing by special appearance of a general grounding.
Thank you, sir. This matter is scheduled for a pretrial today. I received a letter from Mr. Martin that was forwarded to the prosecutor's office indicating that he was not able to open the discovery that was provided to him, and requesting that he get another copy so that he could try to get it to work. He indicated that he had tried to go to the library in order to get it to work with no success also. And since that time, Ms. McDuffie, were you able to provide him with another copy?
No, Your Honor, we have not provided another copy. So the issue, I think, is that Mr. Martin, first of all, let me just confirm that when discovery was demanded and ordered at the October 26th final settlement conference, obviously he received it. He picked that up on November 7th. That contained a flash drive with the media, which is MSP WatchGuard video, a copy of the police report, and a copy of the citation itself. So Mr. Martin has received everything that we would provide to any other attorney, except that it's not a link because he didn't give us an email and he wanted it mailed to him. But what often happens is that to be able to view that, you need to possibly install a player on your local computer so that you can, play that video. And if Mr. Martin is going to the library, it's most likely a system that's not going to allow him those types of permissions to do that. So I would encourage that we don't really have, it's not an issue, I don't believe, with what he was sent having some sort of error on it, but I think that he should connect with his standby counsel because the PD's office would likely be able to assist him in viewing that.
Thank you, Mr. Martin. So what she's saying is you have to install a particular application called a player to be able to play that. It's not going to just play on its own. You have to have the downloaded app or whatever it is that you need to play it from that. Download it to your actual computer. When I was a defense attorney, the way we had to do it is to download that player as well. That's the way the process works, sir.
So I don't know. I don't understand how to do that. So, and I object to her saying it's not nothing they sent. You know, it shouldn't be this complicated. It should just be able to review it.
Well, that's how it works for everybody, you and every other attorney, sir. So what she's suggesting that you do is to get with Ms. White, who is your standby counsel, and have her assist you with downloading that so you can review it, sir.
Well, as I objected to before, I don't accept no attorneys because then that would give unlawful, fraudulent presumptions, and I'm a defendant, and along with a lot of other presumptions, which I'm going to be sending affidavit to rebut 12 of the general fraudulent presumptions that's done in cases. Haven't did it yet, but yeah, that's the problem with that.
Well, that is your choice, but that is the mechanism for you to review it. You can utilize what is available to you or you cannot, but those are your choices. I'm going to give you one more chance to figure out how to get that done. If it's not done at the next pretrial, then we'll just keep moving forward. Okay?
Well, no, I objected. Well, you know, I need to be able to.
You can object to whatever you want to object to, sir, but that is what we're doing today. Pretrial in this particular matter is going to be adjourned to February 1st, 2024 at 9:00 a.m. We will see you then.
Hold on, let me write this down. So February 1st?
Correct.
At what time?
At 9:00 a.m.
9:00 a.m. Okay, now this lady you're talking about, what is her name again? I don't have her number or nothing.
Sandra, I'm sorry.
There you go.
Sandra White. It's on the screen there. Can you see it?
Yeah, I see the name, but I don't see no number or nothing. And
Okay. Will you answer our calls? I'm gonna give you the phone number. You ready? I'm
yeah,
gonna give you my office number. 734
yeah,
545
yeah.
3486.
3486. All right.
Okay.
I just wanted to Washington object again to her representing me because, like I said, I'm always of the position to present myself as a man, so I'm not going to give up my right to do that. But but I will contact her if you guys are going to force me, so to say. It's only going to be by force, and not give me no other option to review the video myself due to them not sending something that can be reviewed. But that's all I got to say on that. Like I said, it'll be by force. It's not you know, they're not giving me no other option. So
All right. Thank you, sir. Your objections are noted, and I'll see you back here on February 1st at 9:00 a.m. Okay?
okay,
Thank you. Take care of yourself, sir.
I will. You too.
Bye-bye.
Bye-bye.
All right, this is file 232155FY, People versus Lateria A. Walton. Miss Walton, can you hear me?
Yes,
You're in the bathroom somewhere. Where are you right now?
at my house.
All right. Why aren't you here?
Because my ride ignored me and didn't come.
All right. Well, I could have got you a bus. You're charged with home invasion, second degree, and assault and battery. It's alleged to have occurred in July of last year. You have a jury trial set in front of Judge Pattison for next Tuesday. Your lawyer, Melissa Halleck, is here, and she's been here since 8 o'clock this morning, waiting for you. Did you talk to her before today?
I talked to her at my last court date.
All right, what are we doing here this morning, Melissa?
I did speak with Mr. Marvin with regard to her case this morning. He indicated that it was a different offer than what had previously been offered at her other PCC, that he was not offering a misdemeanor, that with the upcoming trial and now this new assault case, that he would not be, that it would be home basically as charged, that she needs to waive a prelim to preserve some sentencing, possible sentencing negotiations upstairs to avoid possible prison.
All right, so would you like me to simply set up for a preliminary examination for next Tuesday, and you and she could discuss it further?
Yeah, because I do think there's going to be further negotiations with that upcoming trial as well that may change things. I would assume that they're trying to resolve both cases. So, and I have not been able to convey to Mr. Truckee either the changes in the circumstances of my case, which is he represents her on that jury trial.
All right, I'll set this for preliminary examination. December 12th at 1 o'clock. Miss Walton, it's your obligation to be here next Tuesday, December 12th. You can't phone it in. You're gonna have to be here live. So if you need a ride, you let me know and I'll get you a bus pass. This is a felony charge. It's not a traffic ticket. You need to be physically at court. You also have a case next Tuesday. Have you talked to your lawyer, Mr. Truckee?
Yes.
And what Melissa discussed is perhaps they could resolve both cases at once. They're going to bring in 30 or 40 jurors next Wednesday for that trial unless the case is resolved. So your obligation here is to be here next Tuesday, December 12th at 1 o'clock. Tuesday, December 12th, 1 o'clock. Your jury trial is the following day, December 13th. So you need to stay in contact with both of your lawyers. They're working with the prosecutor to see whether they can resolve this. So you're here by Zoom. That's good enough for this circumstance, but you have to be here live next week. Do you understand?
Yeah.
Do you have any questions?
No.
All right, you look quite bored and indifferent to all this.
I'm
These
not
are very-
bored. I'm going through something, actually. Thank you.
All right, well, you're going through something, all right. You have a felony charge pending.
You're
So,
trying to be funny. It's not funny.
no, I don't think it's funny at all.
You're smart remarks. You're acting like it's funny. It's not funny. Like, yeah, you're a judge. You probably don't go through the stuff that we go through. That's not what I'm going through. That's not the only thing. But okay.
All right, all right, it's not the only thing you're going through, but this is more than an inconvenient nuisance. It's a criminal charge with a serious consequence. So I want you to stay in contact with both of your attorneys and physically be here. If you need a bus pass, you tell me and I'll get you one.
Thank you.
All right. All right. She's going through something. All right. I guess we all are going through something, but we'll deal with this. Good luck trying to shepherd all these two cases together. She's entitled to have a prelim if she wants. She's entitled to have a jury trial if she wants. So thank you, Melissa.
Okay, thank you.